Okay. Well, welcome everyone to another Be Informed session. My name is Carroll and I founded Be Informed to help people make good decisions. Today's session will be about estate planning. So before we get into the seminar, I just want to go through a few housekeeping matters. Firstly, this session will be recorded and a copy of the recording will be made available on our YouTube channel. And also, before proceeding, I'd like to acknowledge the traditional owners of this country on which we are meeting today and pay my respects to their elders, past and present. In terms of a disclaimer, this session is being presented to you in Australia, so the laws that have been considered within the Australian legal framework, and in particular for this session, the laws of Victoria will be discussed. In terms of the currency of information, the information is current as of last week, and the information provided in this seminar is general only and should not be considered personal or tailored to your individual circumstances. In terms of Q&A, please send through to me your questions via the chat function, and I will then relay those questions through to Gillian, who is our presenter today, and that way we can coordinate the questions that you have and then get them responded to in a sort of structured manner. Other than that, the seminar will proceed very shortly, and then we'll proceed to Q&A after that, and then we'll close once there are no more questions. So with that in mind, we can get started, and I'll pass on to Gillian, who will take us through this session today on wills and powers of attorney. So Gillian, when you're ready, you can go ahead.
No worries. Thank you for that introduction, Carl. So good evening, everyone. So my name is Gillian Miranzi and I'm from Scanlan, Carroll Lawyers, and I'm a solicitor that practices in wills and estates. I thank you all for taking the time out of your evenings to come to this webinar. And during this seminar, I'll be speaking as to why it is important to have your estate planning affairs in order much sooner rather than later. I presume that you've all come to this seminar because you're either thinking of making a will, or maybe updating your current estate planning, or you just want to find out a little bit more information about how it works and what you need to consider when making a will. So during the seminar, I will discuss what is a will. I will discuss what assets can be included in your will. I'll discuss who's a beneficiary and any Part 4 claims, and I'll discuss the powers of attorney, so the medical powers and the enduring powers as well. So on to the first slide. So what is a will? So a will is a legal document that expresses a person's wishes as to how they would want their assets to be distributed after their death. So a will generally requires 3 things in order for it to be valid. So it must be in writing, it must be signed and dated, and your signature must be witnessed by 2 other people who also need to sign the will. Some common terms that you will find are an executor. So an executor is a person appointed to administer your estate. What does administer mean? It means they have the responsibility to locate your will, to gather your assets, to pay off any debts you have at the date of your death, and to distribute those assets in accordance with your will. Your executor needs to be someone you get along with and someone who is responsible and reliable. They will be required to sign documents on behalf of your estate and also have a good understanding or knowledge of your assets as well. So when you choose your executor, it is really important that you consider their age and their experience when appointing them. We also recommend that you appoint an alternate executor in case your first executor is unable to act. This could be due to health reasons, or they pass away before you, or simply they don't actually want to act. It is a massive administrative task to be an executor. So it is a very important role within a will, and we recommend that you tell whoever you decide to be your executor that they are your executor, or if you're planning on making someone your executor before they pass away. It's really important that they're aware of their responsibilities. Another term that you will find in a will is a gift, which is also known as a bequest. You do not have to leave a gift in your will, pardon me. So people usually leave gifts of personal property. So some examples are family paintings or portraits, jewelry, cars, golf equipment, photography equipment. It is essentially your executor's responsibility to make sure that those gifts go to the appropriate person. And another common term you'll find is a beneficiary. Now, that is someone who is to receive a benefit under the will. I'm going to come back to beneficiaries later on in this presentation in more detail. Now, there's a term called dying intestate. So, dying intestate is if you die without a will. A lot of issues can arise from dying without a will. This can cause family disputes due to uncertainty, and your assets may end up with someone that you would have preferred to not have received those assets. So there is a 2010 case that was heard in the Victorian Supreme Court, and it's Kerry Ann Rowlands, Fraser and Tom. So Kerry Ann was 25 and her husband Jeffrey Rowlands was 30 years old. They were a married couple, and unfortunately they died as a result of a motor vehicle accident. So it was a head-on collision on the 27th of January 2008. They both died intestate, so they both died without a will. Kerry Ann had assets of approximately $272,000 and Jeffrey had a negative estate of approximately $23,000. Jeffrey died leaving a 5-year-old daughter from a previous relationship, and Kerry Ann had no children. Now I want you to think to yourself, who would be the next of kin for Jeffrey in these circumstances? Now, who do you think would be the next of kin for Kerry Ann? What would happen to Kerry Ann's estate? And what would happen to George's estate? Now, the court had quite of an interesting question to answer, and it's not what most people think. So the court had to determine who actually died first, even though they both died at the same time during this motor vehicle accident. So that was a bit of uncertainty, but it's really important to actually decide who died first, because at the time of the death, it actually goes as to the destination of their respective estates. So the court concluded that Kerry Ann survived Jeffrey, so Jeffrey died first and Kerry Ann survived because she was the youngest of the two. So because of this, Kerry Ann's next of kin would actually be her parents. So it would have been Jeffrey if he was alive, but because he's passed away, her next of kin are her parents. If it was the other way and it was Jeffrey, let's say he was younger than Kerry Ann, his next of kin would have been Kerry Ann, but then she's passed away and then it goes to his daughter. Now, the law in this aspect is that the court must determine that the deaths occurred in the order of seniority and the younger is deemed to have survived the older. So, therefore, the estate went to Kerry Ann's parents, and this included any property and bank accounts held by Jeffrey in his sole name or joint names, including motor vehicles. So unfortunately, Jeffrey's daughter and his side of the family missed out because he died intestate. He simply did not make a will. Okay? So the next part that I'm going to talk about in the next slide is assets that are included in a will. So these are a list of some common assets that most majority of people will have. But what majority of people may not realize is that not all of these assets form part of your estate. The ones with the green tick are the ones that you can give away in your will or they can form part of your estate. The ones with the red X do not form part of your estate. So, your estate, the word, is made up of assets held in your sole name as at the date of your death. So there are two parts to consider. So you have to consider who you're going to leave your estate to and how are you going to leave your estate. So there's 3 ways you can leave your estate. You can give your estate to a beneficiary outright. So let's say you die and there's $1 million and you have 2 children. They each get $500,000 cash. They can do whatever they like to it. Buy Ferraris, buy a house. It's all up to them. You can give it to them upon them attaining a certain age. So you have your 2 kids, but they're both under 18. So you say, I want to give them their $500,000 when they turn 25, 21, 30, completely up to you. Or you can leave it to them in a testamentary trust. So a testamentary trust is a trust that is set up after death, and it is controlled by an appointor and a trustee as well. There's a little bit of administrative tasks involved in it, but it's up to the parents depending on how they want to leave their estate. So before considering though how to leave it, you actually need to know what makes up your estate. So we'll start with the bank account example. If you have a bank account in your sole name, it forms part of your estate. If you held a joint bank account with your partner, then upon your death, that bank account will automatically transfer to the survivor. This is called the doctrine of survivorship. So that joint bank account does not form part of your estate. The same thing is if you owned property. If you own a property in your own name, that forms part of your estate and it will form part of your will. You own a property with your partner, then no, it will not form part of your estate, and through the doctrine of survivorship, it will automatically pass to the survivor of the two. Same with cars, same with shares. Now, another common example is some people own property with someone that is not their partner. So, for example, let's say I own a property with my brother. So I own 50% and he owns 50%. Or I own a property with my brother and his wife. So I own 50%, he owns 25%, and his wife owns 25%. That is known as owning the property as tenants in common. So the property is owned in shares. The share that I own, so the 50% share, I can give away in my will. But I need to be mindful. So let's say I give my 50% share to my friend. I need to be mindful that my friend will now own this property with my brother and his wife. So that's known as tenants in common. Assets that generally do not form part of your estate are companies. So a company is its own legal entity and it's usually governed by separate legal documents. Now, whether they're included in your will or not will actually depend on whether you're a sole trader and whether those legal documents are in place. So, for example, a shareholders agreement or a partnership agreement. Another asset are family trust and unit trust. So the trust deed governs what happens if someone was to pass away. Sometimes they can form part of your estate, for example, if you're the appointer or the trustee, but we'll need to have to look at the trustee to be able to determine this. Another common one is life insurance and superannuation. It is really important that everyone understands that superannuation does actually not form part of your estate. You will need to fill out what is called a binding death nomination form. Otherwise, the entirety of your super can end up where you do not want it. So what happens is the trustee of the superannuation fund, so your industry super fund, if you were to pass away without this form, they go through pretty much a hierarchy. So first they'll see if you have a partner. If you're happy with your partner inheriting your super anyway, great, that's what will happen. After that, they'll see whether there's dependents. So let's say you have two kids, one 16, living at home, and you have no partner, your partner passed away, and you have one that moves out of home, living their own life. Your superannuation trustee will look at that and say, well, this person was financially dependent on you, and that child under 16 will receive all of your super. Your other child will miss out. This is the importance of a binding death nomination form. You can allocate who you want your super to go to and how it can be distributed. Another asset that generally doesn't form part of your estate is cryptocurrency. So the reason why I've added cryptocurrency is because it depends on if it is a hot wallet or a cold wallet. So a hot wallet means that the currency is available online and it facilitates transactions between the owner and the end users. A cold wallet stores your cryptocurrency offline using a device, for example, like a USB. It's a physical actual wallet, okay? Now, a cold wallet cannot form part of your estate because you do not actually own it. A service provider owns it. So a perfect example of this is Gerald Cotton. So he's believed to be the founder and operator of Quadriga CX. So that was Canada's largest cryptocurrency exchange. Cotton passed away under very suspicious circumstances on the 9th of December 2018 while traveling to India with his wife. Now, he made a will 12 days before he passed, and he left his wife his entire $9.6 million estate. So this included cold wallets of everyone who used his cryptocurrency exchange, which was worth approximately $250 million. In 2019, the company went into liquidation, so the company went under with $215 million in liabilities and approximately $28 million in assets. So approximately 115,000 customers are owed a combined $250 million in cryptocurrency in his cold wallet, which he was the only person that had access to it because he was the only person that had the password. So Cotton was found to be the owner of those coal wallets, and unfortunately, those 115,000 people weren't able to get their money and their funds. If you want to read more about the case or find out more, his exploits have actually been subject to a Netflix documentary titled Trust No One, The Hunt for the Cryptocurrency King. Now, on to beneficiaries, which I said I'll get back to. So most people leave their estate to their partner, husband, wife in the first instance. And then if something was to happen to them, it usually is children or siblings, nieces, nephews, or grandparents. However, for some people, it is actually not that straightforward. And for some common examples of what people do is they might decide to divide their estate by giving 50% to their partner and another 50% to be split equally amongst their children. Or if you come from a blended family, you might want to make certain arrangements for adult children, younger children, grandparents, or you might even own a property in your sole name, but you like to give it to someone specifically to live there for a specific amount of time after your death. If any of those above circumstances apply to you, then I recommend speaking to myself or an estates lawyer about the above circumstances and how you can accommodate that in your will. The reason why it's important is because there's a thing called Part 4 claims or family provision claims. So if someone has been left out of a will, or you know someone that's been left out of a will, or you think you were inadequately provided for in a will, then you are able to apply to the Supreme Court of Victoria for greater provision under what you call a family provision claim or Part 4 claim. There is a case called Lucas and Salmon, and it's about a blended family that had a lot of misunderstandings. So George and Jill met in 1999 and they married in 2003. They each brought 2 children from prior relationships to their marriage. In a very terrible coincidence, they were both diagnosed with bowel cancer in 2009. Jill had a will dividing her estate equally between her kids and granting George a life interest in the property that she owned. However, prior to Jill passing away, that property was sold, and so her and George's assets consolidated. So George earned much more money than Jill and made the bulk of financial contributions to their jointly owned assets. Jill died first in 2016. By then, her sole asset was an interest as a joint tenant with George in a property, which he received from the death of his previous wife. So through the doctrine of survivorship, he owned this property. And so all Jill pretty much had was $200,000 in super and jewelry. On her death, her kids had rights to claim on her super or get a provision from her estate. However, her kids didn't do this because they had a conversation with George, who promised to leave them his own super, which was worth $200,000 as well, so exactly the same as Jill's, plus some life insurance and a quarter of his estate. So based on this promise, the kids made no claim on Jill's estate or super, and then which passed solely on to George through that doctrine of survivorship. Regrettably, unfortunately, after Jill's death, the kids and George's relationship became strained. So by the time of George's own death, George had moved on with a new relationship, which resulted in a third marriage. Plus, there was also a misunderstanding about where Jill's jewelry was supposed to go to, and that drove a wedge between Jill's kids and George. And since then, George made 3 more wills since Jill died, and the last 2 excluded Jill's kids altogether. So Jill's kids brought a family provision claim to the Supreme Court, and they sought to enforce George's promise that he made to them before he passed away. The court found that George's promise was actually too vague to be a contract, but it was sufficient to give them only his super, which was $200,000, due to a doctrine called estoppel. So the children's family provision claim succeeded. It's not exactly what they wanted. They got his super. But however, if George had not made that promise to Jill's children, their claim would have been much more unsuccessful, and they would have missed out on inheriting anything under their mother's estate. So it's really important that when you make a will that you consider, if you are considering leaving anyone out or inadequately providing someone, you speak with an estate planning lawyer. Now we'll move on to powers of attorney. So in Victoria, there are 2 powers of attorney documents. So there's medical treatment and enduring power of attorney. So a will comes into effect once you have died. Powers of attorney operate while you are alive. So the appointment of medical treatment decision maker, so it gives someone the power to make medical choices for you if you are unable to. When I say unable to, this does not mean someone that's mentally incompetent. You could be in hospital unconscious and the doctor needs to speak to someone. And that is when your medical treatment decision maker will make choices for you. Therefore, it is really important to tell who you select to be your medical treatment decision maker, what you think about life support. And life support is something that you speak about with your GP or your doctor as well, because there is a separate form that you will need to fill out. Surgery, you'll need to tell them what you think about medication, and also it's important to disclose your medical history to them. So you are essentially giving someone power to make decisions about your health care and medical treatment when you are unable to. So if you're married or in a de facto relationship, then that burden will automatically fall onto your partner. But it's important that you nominate someone that can handle that pressure to make really hard decisions, and nominate someone you trust will have your best intentions at heart. The next power of attorney is the enduring power of attorney. And these attorneys make decisions regarding financial matters only, or personal matters only, or they can make decisions regarding both financial and personal matters. So the term enduring just means the power will continue even when that person loses their mental capacity to make their own decisions. Financial matters, so financial power relates only to financial decisions that you will make. So for example, you can be playing a high contact sport and you injure yourself and you're unable to attend an auction on the weekend for a house. Your financial attorney can attend on your behalf. They can sell property on your behalf and they can withdraw money from your bank account on your behalf. So it's very important you select someone who is good with money and finances. Most people in the first instance would select their children, but if your child is a teenager or quite young, just remember it is a very powerful power and they would be in control of your finances. A personal matter power, so that relates to lifestyle choices. So for example, if later on in life you need to be placed into a nursing home, then that attorney will make that decision for you. So you can choose the same person to be a medical attorney and also your financial and personal attorney. It's important to note that there are laws in place to ensure that appointed attorneys do not misbehave or misuse their powers. So the attorney cannot vote on your behalf. They cannot make decisions in regard to the care and well-being of children. They cannot make or revoke a will. They cannot consent to a marriage or a dissolution of a marriage. They cannot manage the estate, your estate pretty much on your death. So for example, they cannot act in an executor's capacity unless they are actually appointed as executor of your estate under your will. So the attorneys have to act in your best interest at all times. So they cannot withdraw funds from your bank account and go to Crown and gamble it, for example. That is a criminal offence. We at our firm have even had attorneys serve jail time for misappropriating funds. And we've also stopped attorneys in the past from selling properties owned by their elderly parents, and their parents, it's unbeknownst to them, and they have capacity to make their own decisions, or because these children wanted to have an early inheritance. So if an attorney claims that you have lost capacity, it needs to be substantiated by a doctor who has performed the necessary tests and scans. So we always recommend appointing 2 attorneys, with one being a backup or an alternate attorney in case your first attorney is unwilling or unable to act. So this concludes my quick short presentation on wills and estates. Thank you all for coming and listening and participating. I hope I've convinced you all as to the importance of having a will and having your estate planning affairs in order. If you wanted to have a more in-depth discussion regarding your personal circumstances, my details are on the next slide. And this next part I think is open for any questions.
So thank you, Gillian, for a very insightful seminar. I think you've covered a lot of content in a very short period of time, which is great. So thank you, Gillian, and her details are on screen. So if you do have any requests for information or want help, feel free to reach out to her so that she can provide you with more personal and tailored information about your estate planning. So we'll move on to Q&A, and we will first start off with the questions that we've received by email prior to and actually during this seminar. So Gillian, I'll just throw questions at you at random. No, we'll go through our structure. We'll start off with the wills questions, and then we'll go through powers of attorney.
Okay.
And then you can just sort of answer them as we go along. So one of the first questions that we've got is around invisible wheels storage. A lot of people, I think this person has asked whether it needs to be stored anywhere. I think this person has been told that it needs to be stored with a lawyer and or not. What are your thoughts on where the will should be stored?
Yes, so I think the original wills definitely need to be stored with a lawyer, just because we have at law firms, they have deed rooms and everything is safely stored and labeled. You will be provided with a copy of your will because your will is such a delicate and important document. If you are to lose it and there's no copies, then the last previous will that you made will actually be deemed to be valid. Or if you didn't even make one, then you're considered as dying intestate without a will. So I'd recommend for safekeeping. Some people keep it at the banks. The banks have safekeepings as well, or in a safe. But I recommend keeping it with your lawyer. Also, wherever you do store it, make sure you tell your executor, the one that will be administering the estate, where your will is. Because the last thing you'd want is your executor to not know where your will is, and be calling around random places frantically. It's quite stressful.
Okay, all right. So I think that's sort of good words of wisdom, especially when that document exists on paper and is pretty much considered sort of complete when it's when you follow those very straightforward processes, right? And there's another question we've got in terms of witnessing. That you mentioned that you require two people to witness the document. Are there any sort of other particular requirements around that process? Like, can they just go to a police station and get to police office? Like, how straightforward is the witnessing process?
It's quite straightforward. So it doesn't have to be prepared by a lawyer. We've had wills in the past that have been prepared at home by someone and they've got two adult witnesses. It's just really important that those three guidelines that I said are thoroughly followed. So if you make an error, for example, on your will, it's important that your two witnesses also sign to that. If you sign the bottom of every page, your witnesses have to sign the bottom of every page. If they miss out on one, it's a really, really big issue when trying to obtain probate after you've passed away. So my biggest thing for that is if you have your two witnesses, you can type up your own will. People have done that, as I mentioned. It's more preferable if you do speak to a lawyer just to make sure that it is done accurately and correctly. But as long as you have your two witnesses, you sign the bottom of every page. If there's an error, everyone initials it. It should be good to go. But like I said, I always recommend speaking to a lawyer and getting them to look over it.
Sure. Yeah, I think that's important given how valuable that document can be if you get it when you get it right. So the next question is around doing it yourself, DIY. What are your thoughts on that? I know you're a lawyer, so you want people to come to see a professional, but there are a lot of DIY kits out there. In summary of this person's question, can it be trusted?
Yes, that's right. So there's a lot of do-it-yourself kits around. You can buy them at Australia Post. They're around, and look, some of them pass, but as you said, I'm very biased, and I recommend you go and get a legal professional to make your will for you. So speaking from experience, the wills that have been DIY have caused the most problems. That's because the court will always be seeking to clarify whether A, it's a legitimate document, or whether it's something that a random person has just typed up and said this is the last will. B, it might not have been executed properly, so names, dates might be wrong, different colored pens may be used, and that's a really big issue too that people may not think of. So it's really important that a will is executed at the same time. If you use different colored pens, then it's an invalid will. And if you don't have another will, like I said, you've died intestate. So I always recommend going to see a lawyer. If you are going to do it yourself to save a bit of cost, at least get a lawyer to look over it. At least I think that's just a safe option. Yeah.
Yeah, cool. I think that's I wasn't aware of the different colored pens situation. If they
Yeah.
imagine that not everyone will have the same colored pen when they're getting it filled out and witnessed and all that. So
That's right. And just further to that as well, even stapling the will as well is a really big thing. To look at markers just in case they might think, oh, you've left out a page, or it's a very serious document. Yeah.
okay, all right, that's good to know. It's very good to know. Another question that we've got prior to the session has been around appointing an executor. Um, can they disappoint a relative, or is it better to get someone that's equipped and knows what they're doing? Yeah, I think the question is whether to get a relative or do they engage a professional to sort of to be performing that role.
Yeah. Okay. So it really obviously comes down to the person.
Mm.
If you do choose, it's up to you. So we've had in the past people appoint solicitors and accountants or even appoint two executors. It's really the choice is theirs. If they appoint a family member, as I mentioned, it is a really big administrative task. So you want someone that's very organized, someone that can keep on top of things, someone that's quick to respond. So they'll be dealing with banks, they'll be dealing with lawyers, they'll be doing tax. So it's a very, very big task. If you get overwhelmed, it will slow the process, and also as well, it'll just become too much. So if you want to choose a family member, go for it. That's absolutely fine. Just make sure they're very good at their administrative tasks and they're an organized person and they're a balanced person. So with a lot of death, sometimes can come a lot of family disputes. So you want an executor that if one beneficiary is telling them something, and they can just be like, no, this is the way it has to be done. This is the will. So you need someone that can stand up to people as well and be tough in their decision making. So with that being said, that's why some people choose a third party, like a solicitor or an accountant, because we're completely detached from the situation. We don't know who the beneficiaries are. We don't know your family. People can't really say anything to us. So it's up to them. There's no right or wrong. You just want someone that can get the job done. Yeah.
Right. Okay, good to know. The next question that we've got is around assets. So I think you've gone. I think you've already mentioned this during the seminar, but probably best to reiterate it, given it's quite prevalent to have joint, bank accounts with your partner. Just remind us what happens, if you do hold funds jointly with your partner. What's the best way to make sure that that's disposed of or distributed correctly when you do pass away?
Yeah. So if you held a joint bank account, as I mentioned, joint assets automatically pass to the survivor of the two through the doctrine of survivorship. If you're happy with that, then there's actually nothing you need to do, just the way it's going to be, it's automatically going to pass. If for some reason you are part of those special circumstances that I mentioned, where you'd like your bank account, for example, part of your joint assets, half goes to your partner, then half to be split amongst your kids, that's a different kind of conversation. It's a little bit more tricky because it is in joint names. So you would actually have to do the transfer while you're alive to a sole bank account to be able to control that bank account assets. Otherwise, your partner will just argue, and it's a hard thing to argue like who put money where, because your partner might say that's my money. It gets a bit messy. So if there's funds that you do want to leave to a specific beneficiary that's not your partner from a bank account, for example, I recommend you transfer the money out to a sole bank account, and then you have sort of control what happens to that, unless your partner agrees and says, yep, I'm happy to do that. But that's probably the best thing. That's the cleanest thing to do. And that avoids any disputes.
Cool. Okay. And this is a bit of not a curly question, but a question with a bit more facts to it. So this person's asking that. Sorry, I'm just forgetting was. So this person's asking that they are currently in a situation where one of the relatives has passed away. One of the relatives has another living relative has tendered a will of the deceased relative, but they don't believe that it's the most current will. They think there's another copy out there. What can they do? God knows where the will is, right? But what can they do to find where that document could be, or can they challenge it? Don't even have to go through the whole length and breadth of that approach, Gillian, but what are your sort of thoughts on that? I'm assuming it's a quite common scenario where there's multiple wills and might not be in the right favor of some, and yeah.
Well, to start off with, I think whoever that person is needs to get in contact with me to definitely go through that in detail and see how we can further assist them. But generally what you're looking at is if you believe that the will that's been made is not the last one, it'll depend on whether you're applying for a grant of probate or not. If you're applying for a grant of probate, the executor will have to sign an affidavit saying that this is the last will and testament. You can challenge that. You can challenge that via the Supreme Court. The only thing is, you need to kind of have an idea where that last will is, or
Mm.
there needs to be some mention of where it could be a file note, it could be a text message saying I made a will last year and the one they're using is from 2020. You do need evidence to back it up that there is another will. We can make efforts to try and locate the other will as well, especially if it was made a lawyer. If it's a DIY kit, it might be a bit more difficult. But in those circumstances, that person needs to speak with a lawyer, speak with me, and we can definitely assist them more. But you can challenge it. You can definitely challenge if you think there's another will out there, because it needs to be the last will and testament. And also, if you think that that will was made invalidly, for example, that person lacked mental capacity, we'll just need the evidence to
Right.
bring that argument forward. Yeah.
Yeah, so I hope that person is watching today or listens to the recording, gets in contact with you so they can ensure that the right process is being followed. One question that we've got as well is just quite, I think it's an interesting question, is around electronic signatures and that in that space. So can these be signed electronically? Can this be, can the witnessing be done electronically as well? What are your thoughts on that?
So during around the COVID pandemic, the government did allow for electronic signatures on wills. So it was a short time lived. That is now gone. So they're no longer allowing electronic signatures. It has to be hand witnessed using the same pen by two witnesses. So during the COVID time, that was fine. And there were strict procedures in place as well. Like, for example, the camera had to be positioned so you can see someone actually signing it. It gets scanned and then everyone sees it. So therefore, you've actually witnessed it. But in this day and age, no, it has to be in face, person to person, because it's such an important document. And with electronic signatures, you can obviously see why. It would be very, very easy to create a fake document saying it's someone's last will and testament. So they need to put in practices in place. Yeah.
Okay, so basically wedding and everyone in the same room, same pen.
That's right.
Same temperature? No, okay, that's in case the temperature sort of impacts the ink when it's sort of, anyway, I'm getting technical on that. All right. Yeah, it's good to make, sometimes unfortunately these topics can be quite sort of, not depressing, but a bit what's the word? Lacking color, I guess. So good to sort of think about them in a different manner. All right. Another question that we've got is around beneficiaries. So can someone that's written a will leave their estate to a company or to a trust? Probably a bit of a
Yes, they can. So anyone can be a beneficiary. It can be a person, it can be a company. You get it quite a bit. So some people might say, I leave 50% to a superannuation fund, a self-managed superannuation fund if they want to any company. It's really up to you. You can leave it to whoever you want to leave it to. It's your will and it's your estate. So yeah.
Okay. So that's good to know. And we've received, probably a good time to ask the question that we received through the chat function. For the Part 4 claims that you've mentioned, the family provision claims, the person's asking, is there any time limits on making a claim on that estate?
So yes, there is. So once someone has passed away and the executor starts, gathering all their assets and knows the net pool of the value of the assets, then you apply for a grant of probate. As soon as that grant of probate has been granted, you have 6 months. So if someone wants to bring a claim, they have 6 months from the grant of probate date. Now, not anyone can just bring a claim. I didn't go into so much detail in my presentation. You need to show that you had a dependency on the person that died. So great Auntie Martha from Canada can't just show up after you've passed and said, Gillian left me out of my will. I want something. She needs to show that she had some kind of dependency on me. So that's also a very important key factor as well.
Okay, cool. All right. Yep, that's good to know. We'll jump on to the medical treatment decision-making makers. And I think we should just clarify that that's sort of a Victorian concept. There's different concepts that exist in different states in Australia. It's not a uniform law across all jurisdictions. And in relation to that, this person has asked whether, can they appoint more than one? It just
Yes,
has to be okay. They can, and how
yes,
does
they
that sort of
can.
work around joint decisions and all that sort of thing? Is that sort of prescriptive and simple to understand, or should they come and speak to you further?
Always come and speak to me further, but in short, yes, you can appoint more than one. You can appoint two if you want. The only reason why, from my perspective, we don't recommend doing that, we recommend appointing one and then having an alternate, is just for practicality reasons. So that's two signatures that you will need. If the doctor wanted someone to sign a document, like I said, that's two signatures. You both have to be there. If one person lives interstate and one lives in state, it's just easier to have the one. But you're more than welcome to have two people making the decisions for you. They're very big powers and very powerful powers, but we recommend making it one and then having an alternate when one cannot act.
Mm-hmm. Yeah. And another question that we've received, I'm not sure about the intention of this question, but I'll say it anyway. What, so enduring powers of attorney, right? They activate when you lose capacity. Um, what happens if that person then regains capacity? Not sure if that's medically possible, or it could be. But have you ever come across a situation like that where it could terminate on person regaining capacity?
So no, I haven't had that particular
Mm,
circumstances. So to answer the question generally, then I'll tell you about a case that we had. So if you lose capacity, you need a doctor's certificate saying that person has lost capacity. So if they do then regain the capacity, you will need a doctor's certificate saying this person has regained capacity. That will be sufficient to satisfy that test.
mhm.
Um, so before, you make a will or anything, we'll always, especially if they're a bit older and more frail, we'll always ask for them to go see their doctor just to make sure that they do have capacity in what they're doing. A case that we had was we had a lady who was blind and she went to her doctor and her doctor incorrectly classified her as not having mental capacity because she was blind. So that caused a little bit of issues because her attorneys were going around doing things that they were not meant to be doing because she actually had mental capacity. So we had to go back to the doctor and the doctor had to change his letter and recommendation and say, sorry, just because you're blind doesn't mean you don't have capacity. And as a result, she was able to enter into a property transaction and she was absolutely fine. So it doesn't really answer that question in that way, but it just shows you that you just need that doctor's certificate saying that person has capacity
Mm.
and you'll be fine. Yeah.
It all relies on the expertise and the goodwill of that doctor to make sure they're making the right clinical assessment, right? Because in that period of time, that individual could have been exposed to the attorneys going off buying houses and all that, and then as we know in
That's
property law, it's very hard to reverse those transactions once they're cured. So
right.
yeah,
Exactly
good to know.
right.
Yeah, so
Exactly
that's a
right.
very important assessment at that point in time.
Mm.
Okay, so that sort of concludes all the other types of little questions. I'll just go to the chat to see. So we've got one other question here, which is around if I've loaned someone money, can I make provision for that in my will so that it's paid back to my estate on my death? Do you see
Yes,
this
you
in practice?
can.
That's an interesting question. Yeah, what are your
It is a
thoughts on that?
very interesting question. It's a very good question as well. So yes, you definitely can.
Mm,
So let's say a common example is with children. So some people might lend one child funds to put a deposit down for a home, and one
mhm,
child might not ever receive those funds. So in the will, they just say that I lend whoever, let's say $1 million, to that child to receive $1 million less when it comes out to distributing the estate. So it's very, very common for that to happen. If you loan someone money, you can request it to be, there's two ways you can do it. You can request it to be due and payable upon your death. So as soon as you die, you want that money straight away and it forms part of your estate. Or as I mentioned, you just say that if it's a beneficiary, for example, that person just gets less in their inheritance.
right. Okay. Okay. So that'll probably have to be drafted quite carefully in the documents, yeah, so that it's clear. So I think we can sort of summarize it from the DIY question that we've got that, I think DIY could sort of go to a certain extent, maybe,
That's right.
probably covering 10 to 20% on what's sort of there. But yeah, the more complex the estate is, then it's best to get it drafted professionally.
Mm.
So that actually sort of exhausts all the questions that we've got. So what are we for time? 6:47. I think that's been a good session. So I think Gillian will wrap up there, and I'll just share the screen for closing remarks. So, all right. So yes, that concludes Q&A. So again, yeah, thank you to Gillian. Her details are on the screen if you want to connect with her, ask her a question. Feel free to contact her directly. And that's about it. So that, yeah, thank you for attending the session. Just going through my notes on the, yeah, so thank you. Yeah, thank you for attending the session. A copy of the recording will be posted on our YouTube channel. So after the session, it'll be uploaded to YouTube, so you can have a look at that if you wanted to go back and check on anything. And feel free to share it around as well. I found it Be Informed. I've done it personally. There's no affiliations or sponsorship or donations, so I just rely on word of mouth to sort of get the word out there. My key intention, my sole intention, is just to help people make good decisions by being informed about information that matters to them. Gillian has also kindly prepared a one-page handout, which will be emailed to all registered participants. That'll come through by email if you register through Eventbrite. It's a one-page document which summarizes key points from the seminar. Yes, please follow us on social media. As I mentioned, that's important for us. And if you've enjoyed the session today, please share it around and tell people about it so more and more people can tune in. Our next session will be on Wednesday, the 29th of March, in a fortnight's time at 6 p.m. It'll be on child support and child inclusive mediation. And then sessions in April will be covering consumer credit files, mortgage brokering, what to do when you want to find a loan, and tips to deal with a mortgage broker, and other topics around potentially finance, tax, and accounting matters. We're just trying to settle a few presenters. So yeah, there's more to come. And I think that's about it. So that concludes the session for today. Thank you all for joining us. And thank you once again to Gillian and Scanlan Carroll for presenting today. And with that in mind, we'll close. So have a nice evening.
Thank you. Thank you for having me.
See ya. Bye for now.
Bye.